dialogue, it is now my honor and privilege to yield to one of those individuals that Representative Beatty mentioned as really a legal giant amongst us, someone who has served this institution well, who understands the Constitution, the notion of separation of powers, and the importance of a fair and equitable justice system. I yield now to the distinguished gentleman from Virginia, Representative Bobby Scott.
Thank you, and thank the gentleman from New York and the gentlelady from Ohio for organizing tonight's special order to call on our colleagues in the Senate to do their job and provide their advice and consent on the President's upcoming nomination to the United States Supreme Court. The Constitution is pretty clear on this issue. Article 2, Section 2 doesn't say the President might or the President should. It says the President shall nominate and by advice and consent of the Senate shall appoint judges to the Supreme Court. Now, there seems to be some suggestion that if it's an election year, he ought to skip that process and let the next President make the appointment. They say there's very little precedence for a President nominating somebody in an election year. Well, that might be technically correct, but the fact of the matter is there have been virtually no vacancies that have occurred during an election year. I think the last one was about 50 years, almost 50 years ago, and in that case, an appointment was made and considered, and that's the process that ought to take place in this case. The rarity of such an event should not preclude the Senate from fulfilling its constitutional responsibility. There is precedence for the Senate actually for the President nominating and the Senate at least considering the nomination during an election year. Now, Justice Kennedy was confirmed in an election year, 1988, and that was a 7-month process that began with the appointment of Robert Bork to the Supreme Court. His nomination was considered and defeated. And then there was the appointment of Douglas Ginsburg, and we'll just say his nomination went up in smoke. And then the nomination and confirmation of Justice Kennedy. 7 months from start to finish, consider defeat, another nomination made and collapsing, another nomination made in 7 months. We could complete that entire process by the first Monday in October, the beginning of the Supreme Court session. There is no precedence for the President declining to nominate somebody, and virtually no precedence for the Senate just to ignore a nomination that's made. The people overwhelmingly reelected President Obama in 2012 to a term that does not end until January 20th, 2017, and we fully expect the President to fulfill his duty to nominate a qualified individual to the Supreme Court to fill the current vacancy. A failure of the Senate to act this year would be unprecedented. There's ample time for that to take place. The longest confirmation process for a single nominee has been 125 days. On historic average, 25 days it takes to confirm or reject a nominee. As of today, the Senate has 216 days until the first Monday in October. If the Senate were to refuse any of President Obama's nominations, and the Senate has and they've said we want the next president to make the appointment, there has been no indication that they will give expedited consideration to the next president's nomination. It could well be well into the next year by the time the new justice is confirmed and sworn in. Or even on an expedited schedule, the new president would not be able to nominate anyone until they are sworn in on January 20th. The Senate Judiciary Committee would need time to prepare for hearings, which could not occur until probably February, and then the full Senate would need time to consider the nomination, with the confirmation not likely until probably March. Now, by March of a term, the term is effectively about over. Most of the oral arguments have already taken place, and they're into the decisions. You can't participate in a decision if you skip the oral argument. And so not only would the vacancy occur through the rest of this term, almost half of a Supreme Court term, it would be well into the next term and effectively through most of the next term. There is no excuse to leave the court vacancy open in what then would be a historic new precedence. There's no precedence for keeping a vacancy open that long. We need the justice appointed. The Supreme Court, the Senate ought to do its job. The President has indicated that he will do his job as mandated by the Constitution. And so the Senate ought to just fulfill its responsibility under the Constitution and consider an appointment. Otherwise, you'll have a vacancy not only through the rest of this term, and oral arguments have been taken place. You'll have the vacancy through the rest of this term. You don't need a vacancy through the entire rest of the next term. There is plenty of time to consider and vote up or down on a nomination. And the unprecedented vacancy that would occur if the Senate fulfills its threat to stonewall any nomination is just unprecedented. So I want to thank the gentleman from New York and the gentlelady from Ohio for giving us the opportunity to just say a word about the importance of everyone in our democracy fulfilling their constitutional responsibilities. The President shall appoint, and the Senate shall consider, advise, and consent so that we can have a Supreme Court justice appointed before the first Monday in October. We have plenty of time to do that. There's no excuse for not doing it, and we expect the Senate to do its job. Thank you very much, and I yield back.
Distinguished gentleman from Virginia for highlighting several important points, including the fact that there is no election year exception in Article 2, Section 2 of the United States Constitution.